we have a special guest speaker today that I'm really excited about. And this gentleman to my right, Mr. Cullen Seltzer. He is a UW graduate. I guess at that point it wasn't UMW.
It was MWC.
MWC, Mary Washington College in 1990 with a degree in international affairs.
Yes.
Is that correct? That's excellent. After that, he studied law at the University of Richmond, where he received his Juris Doctor in 1993. And as I understand, he won their moot court competition. I didn't know you did moot court. That's awesome.
I did.
That's great. And also published in the University of Richmond Law Review. He's practiced law since, has been recognized in Virginia Business Magazine's Legal Elite, in Super Lawyers as a Rising Star, and Best Lawyers in America for Mass Tort Litigation. He's also an adjunct professor at the University of Richmond's Law School, where he teaches a number of courses, most recently legal ethics, I believe, is that correct? And he's a shareholder partner attorney at Sands Anderson of Richmond, where he's practiced since 2011. So I'm really excited to have Mr. Seltzer here. He and I have had a lot of discussions over the last several years about developments in AI, certainly lots of concerns about AI, and when we think about that from the legal practice, there's a lot on the line. This is not a field where you can just go out and try crazy things without worrying about what that means for exposure for yourself or for your client. So a little more traditional perspective on a lot of developments I've found with lawyer friends. But there have also been discussions about how his practice has been looking into incorporating AI where it would be appropriate, when it's responsible to do so. And I'm sure you'd be happy to answer any questions you have about that a little later. Even if you're not planning on going into law, it's really great to hear from somebody, a professional in their field, who's grappling with some of these same issues and discussions about how is AI changing our discipline, our field. What does it mean for the way we're going to adapt? And hopefully maybe he'll have some advice for you all on how this might help you chart out your course looking over the next few years. What should you be ready for, whether it's law or some other field?
All right. Thanks, everybody, for having me. It's nice to see you. It's nice to be back on campus. My daughter graduated from here just a few years ago. It's very exciting. I came here when she was touring campus, and I embarrassed her a lot. Everywhere we went, I was like, "That's what we should do that there." And she's like, "You've got to stop telling that to strangers." So anyway, it's a treat to be back. Thanks for having me, and thanks for being interested in artificial intelligence, which I think is going to be principally your job for the rest of your lives. I don't have to tell you, you guys have been talking about artificial intelligence for a while now, that it's been revolutionary in almost every segment of business and commerce and government in our everyday lives. I really cannot believe that ChatGPT went live 3 years ago and was available to people. It is shocking to me how transformative it has been in everyday life and in our business. Dr. Rao and I were talking that our firm right now is in the middle of trying to figure out which AI tools we're going to make an investment in. And we're making that decision not because my partners are all technologists and cool, excited about some cool new fancy piece of technology. We're talking about making that considerable investment because our competition isn't going to make that investment. Our clients expect us to be able to use that tool. And if we don't, we can't keep up. And that transformative piece of technology happened 3 years ago. I've been doing this now for more than 30 years, and there has been nothing in my professional life that's been remotely akin to it. How AI affects lawyers' ethical obligations. Anybody, just by show of hands, anybody interested in being a lawyer? 2. Well, that seems about right. All right, so when we talk about lawyers' ethical obligations, we're not really talking about lawyers' morality. That's not what we mean by ethics in this context. When we talk about ethics, what we're talking about is what duties do lawyers owe their clients? What duties do they owe courts? What duties do they owe the public when they're doing their job as lawyers? And so we have a pretty extensive body of rules that govern our ethics. You may or may not be surprised that we have rules that govern what kind of fees we can charge. Somebody just sighed. Get that a lot. So our fees, unlike the fees that many businesses charge, our fees have to be reasonable. We can't charge unreasonable fees. And you know, well, what makes a fee reasonable? Anybody have a guess? What makes a fee reasonable? I'm going to just call on you. It's going to be embarrassing. Yeah.
Well, it really depends on the case.
Yes.
Like case basis. Like for example, like if it's a criminal case or something like that. Now that's more of an attorney thing than a lawyer thing, but that would cost a lot of money because it also depends on does the wife and the husband or something, do they have like a joint bank account? It's all very complicated.
Sure. So exactly right. The complexity of the case makes a giant difference. What else? Yeah.
Well, you don't want to charge, for example, Joe Schmo the same thing as you charge Al Capone. I mean, there's different kinds of money you can lie sometimes, but we have an expectation here in the U.S., thankfully, that you're going to be able to get a lawyer no matter what. If you can't, well, you have a public defender to help you in the case, but it's just being able to have a bracket for everyone that you'll have some kind of defense in that time of need.
Sure.
About it when you don't.
Correct all the way around. One of the things that makes a fee reasonable or not is how complex the case is. One is, what will the market bear? Right? What is the market in the community that you're doing the work? What do they think this case is worth? Right? Yeah.
Time spent.
Time spent. Right. Time spent is the measure that, and we'll talk about this here in a second. Time spent is the measure that many, many lawyers use to assess the reasonableness of their fee. You'll hear people talk about billable hours. When they're talking about billable hours, that's what they're talking about. So the question has come up, if it used to take me 10 hours to do a task, right? And I billed $2,000 to do that. And now with AI, I can do that task not in 10 hours, but I can do it in 30 minutes. Is it still reasonable for me to charge $2,000? No. Look at you, cynical people. All right. Why not?
Because, I mean, I'm actively involved in a couple of lawyer things right now.
Oh, all right then.
Yeah, it's super fun. And very expensive.
Yeah.
So if before the way that I saw it is that you had to spend that 10 hours, so your time needed to be worth it for you to invest into that case, right? But now you can take that time, cut it in half, you can now charge somebody else for the time that you're not going to use anymore. Because that's what you're going to do essentially, is you're going to go work on another case, still trying to charge $2,000 for 10 hours, now 3 hours of work.
Sure. Anybody else have a different view? Yeah.
I think you can still charge it because it's still your skill as a lawyer.
We're definitely hiring you.
It's definitely like your skill as a lawyer to work out what prompts to ask and how to sort of find the data. Even though yes, it's shorter and some people could take advantage and do like 10 cases in one day.
Yeah.
Which I feel like there must be rules for that. But
So, the state bar, in Virginia, the state bar is mandatory. If you want to be a lawyer, you have to join the state bar, and it's our licensing regulatory agency. So if you want to be licensed to practice law, you got to pass the bar exam, you got to get admitted by the state bar. The state bar publishes these legal ethics opinions that help explain how to apply our rules. This one, 1901, the Supreme Court hasn't yet approved it, but I think they're going to approve it. This will be the very first legal ethics opinion in Virginia that deals with anything having to do with artificial intelligence. And go figure, it has to do with lawyers' fees. Let me go back on that. So I'll just tell you what this answer is going to be. And the answer is going to be that the court has said, is going to say, the fee has to be reasonable, but all the factors count. So the time definitely counts, but so does the lawyer's experience. So does the lawyer's, the difficulty of it. So does the risks and value to the client. It's a multi-factor analysis, and there is no hard and fast answer. What I think we're going to find out is that ultimately the fee is going to be reasonable based on what the market decides. Rule 1.1, that's our very first rule, requires lawyers to be competent. You might ask, how is it possible that they had to have a rule requiring you to be competent? Didn't everybody know that already? Well, you should have, but we don't. So Rule 1.1 requires us to be competent, and the rule explicitly says that we have to be conversant and fluent with technology. Certainly AI falls into that scope. And Rule 1.6 requires us to keep information confidential. Why is AI a problem for lawyers who have to keep information confidential? Yep.
Data leaks.
Yeah. What do you mean?
So you have to, of course, draw a lot of data from external sources and from the sources that you actually put into the AI models to help you kind of do all that. But who's having access to those files once you put them into the model? So it could be a huge security risk.
For sure. People tell lawyers confidential secret stuff all the time. Sometimes they tell them trade secrets about how a particular product got made. Sometimes they tell them where the body's hidden, right? You can't put that into ChatGPT and have the internet now know. So if you're going to use this for us, you got to be smart about it. Yeah.
I mean, I feel like with anything, it's like email, it's like any database though, like it has to be encrypted.
Yeah.
We're just moving to a different platform than we had before.
What-
Phone calls used to be wiretapped and things like that, so.
Sure. And what our professional regulators tell us is we have to take reasonable precaution, right? None of us, no Fortune 500 company can guarantee to any of us that all their data is secure all the time. You see data leaks all the time, yeah?
Our data is also for sale. You can practically buy it if you want to. If you have the means, you will be able to find a way. If you're some enterprise lawyer, prosecutor, going after someone, you know you can get that information. You got the dollars, why wouldn't you?
Well, I think that's probably true. What I would say is, as it relates to lawyers doing their own work, we can't sell that. There's absolute prohibitions about us selling our clients' data. But it also means that we have to be careful what tools we use. So in our firm, we don't use ChatGPT. We use, what is it? Pilot. Yeah, Copilot. Yeah. Which is in our own firm's ecosystem. Doesn't mean we couldn't be hacked. We could. Somebody else? All right. Now we just talked about the fees, what's reasonable. All right. Lawyers cannot stop talking about it. We don't truly understand it, but we talk about it and we think about it all the time. You guys seen this movie? Ah, you have? Or you want to talk about, you've seen clips. Well, I guess that's pretty good. Okay. Well, this is not as clever a joke then, if you've never seen the movie. Minority Report was a movie, I don't know, 20 years ago. Before you were born. About a technology that predicted people's criminal activity. Generative AI is a predictive technology. In Virginia, we use a version of this already. It's not strictly speaking predictive, but it's analytical in a way that has a predictive component. And in this context, what you see on the screen is what's called a Praxis, a Virginia Pretrial Risk Assessment Report. And what that does, if somebody gets charged with a crime and the court has to decide whether to hold them in jail or not, or release them on an electronic monitor, or release them on a cash bond, or just release them on a personal recognizance, you have to kind of figure out, well, is this person a good safety risk to do that? Are they likely to come back to court? Are they going to hurt somebody and they're allowed to stay on the street? This tool allows probation officers and judges and prosecutors and defense lawyers to kind of type in what somebody's criminal history is, what the charge is, and draw on a giant pool of data from cases in Virginia. There are hundreds of thousands of cases that happen in Virginia every year, and we've been doing it for many, many years, to ask ourselves, well, what kinds of people are good flight risks, safety risks in the community? So we've been using this tool for some period of time in Virginia, and it's a tool that helps judges, in particular, figure out whether to release somebody. And Virginia law now requires that that these be available. The law just changed on July 1st of this year. And the highlighted language, the use of any recommendation or prediction from an artificial intelligence-based tool shall be subject to any challenge or objection permitted by law. And the sentence before it, no decision shall be made without the involvement of a human decision maker. So this technology has been available for about, at the time this law was passed, for about 24 months. And the legislature thought that it was appropriate and necessary to say, hey, judges, we're not farming out your job to robots yet. In fact, it made it illegal for them to farm out the robot. The robot can give us advice, but it can't make the decision for us. I know that you guys have heard the many, many stories about lawyers getting in trouble with turning in hallucinated cases in their legal work product, right? We've got a case here, I'll just draw your attention to it. There's nothing really exceptional about this case, it's just a good example of it happening. The lawyer submitted briefs in court that had hallucinated cases. And this is an interesting case. This was an AI agent that the lawyer's law firm had commissioned to have built for themselves. It wasn't a publicly available one. They built it just for them. And the lawyer asked these questions. Add to this motion federal case law from Wyoming, and add case law regarding motions in limine. It generated fake cases. Mr. Ayala, the lawyer, didn't verify the accuracy of the cases. You guys have used this, right? Obviously. If you want to verify that the sources that these robots turn up for you are real, how do you do it? Yeah. Hang on one second. Don't let me forget that. Say again?
Click on the link that it provides.
Yeah.
Because if you click on the link and then it pops up with an error 404, then it's not credible because nothing pops up. Or you have to check if it's a secure site or not, and it has to be from a trusted source.
Great. Yeah.
Usually I would look mine up on like Google Scholar to see if it's even like a scholarly source, because some classes only want like scholarly sources.
Do you then go look at the specific page, see if it in fact said that? Yeah. Yeah.
I agree with what you're saying, but what I normally do is I'll ask Cautionary something, and they're like, can you give me sources for this? And then I'll click on the links to the sources they provide, rather than trying to click on the links they give me. Sometimes they'll be weird, where it does sound weird or something, or I'm also just trying to cite it for our class, and I know I'm not going to be able to put a specific wording. Just give me where you found it, and I can look on that source and send it to you.
Gotcha.
I'm trying to figure out where the heck they found this word.
But you guys sound like pretty savvy, sophisticated users of the tech, so well done. You'll no doubt be teaching people who aren't as savvy and as sophisticated about some of those strategies. Let me ask you this. If somebody weren't doing what you all just described, right, why not? Why wouldn't somebody do that? Yeah.
It's more convenient, it's just faster not to check.
Yeah. You're being very polite. I think what you mean is they're being lazy. Yeah. What else? Why else wouldn't you do it? Yeah, in the back.
You could actually disprove the information you're trying to prove.
Yeah, right. Yes?
Sort of the same point, but like, if they are conscious that it's not true, then why would they check?
Yep. Yeah.
Depends upon, like, say they're like the due date for an assignment and they're rushing to get it because they forgot to do it and they don't check anything and they submit what the AI told them to do.
So we didn't talk, when we were talking about our ethical rules, about the ethical rule that applies to lawyers, and it applies to all of us in our lives, but for sure is written down for lawyers, which is you're not supposed to procrastinate, right? Have you ever met anybody who never procrastinated? Yeah. Yeah.
You have like a huge caseload.
Yeah.
There's too much stuff going on at once.
Yeah.
And you think you can get away with it, you know?
Yeah. You mentioned time, right? We've talked about time. I have clients all the time who ask me, please don't spend so much time on this because I bill them by the hour, right? So there's pressure on both sides of that. I don't know what Mr. Ayala's rationale was. I think actually I do know his rationale. I think Ayala said he really didn't understand what he was doing. It was new technology, he's old, he just didn't know what he was doing. Here's what the court said. Signing a legal document ensures that the attorney read the document and conducted a reasonable inquiry into existing law. That's the rule that governs us. And that's been the rule that governs us from time immemorial. This technology didn't change that rule. And this duty is a non-delegable responsibility. When you take up your lives, your professional lives, it may be from time to time you'll be tempted to blame your secretary or your paralegal or your nurse or some subordinate to you for some screw up that happens. If you do that, the very first emotion you should feel is deep and abiding shame. Take responsibility for your work. It's never anybody else's fault if your name is on it. And what the court here says is Mr. Ayala's fault, even though he entrusted somebody else to do it. And this was their punishment. For the lawyer who misused the technology, he was barred from appearing in that court anymore. Go ply your trade somewhere else. For the lawyers who delegated the authority unreasonably, they were fined $1,000 personally. That's not a fine that you pass on to your client, that's one you pay yourself. And for all three of these lawyers, this opinion is published in the Federal Reporter. So that case now exists forever. Their names will forever be known. Whatever else they do, and hopefully they've done and will do other good and important things, they'll also have done this. All right. When I think about generative AI, I think about all the things we've been talking about. It's fast, it's efficient, it can reach into nooks and crannies of the internet and the knowledge base in ways that I just can't do by myself. So it's a fantastic tool. But I am this amount of concerned about it. When I give an assignment to a colleague and say, hey, listen, I've got a legal problem. I need you to go and research for me what the law is on this particular question. Go and figure it out. I'm asking them to do that for two reasons. The first reason is the easy reason. I'm asking them to do it because I need to know what the answer is, right? I need somebody to go and tell me what the relevant cases are. I need them to tell me what the relevant statute is, and I need them to put it in a nice, neat thing that I can read. That's the easy part. I can do that myself. I know how. I'm only asking for help because I don't have time, right? So I'm asking for help because I need somebody else to do that first part of the task. But here's the second part of the task. I need them to be smart about this problem. I need them to get it. And I need them to get it because at some point, we're going to go sit down with our client. And we're going to have to ask the client to make important decisions in their lives based on the advice that we give them. And we can't give them that advice unless we have good judgment, and we can't have good judgment unless we understand what it is we've researched. I don't really need the sheets of paper. What I need is that colleague's brain to be smart. Which is why, have you guys heard of this study? I was so intrigued to see this study published by MIT. It's a small sample size, about 50 people. What happens to your brain when you use AI to learn? I think there's both good news and bad news here. And we're going to start with some bad news. The study wanted to know what was happening with people's brains when they were using AI compared to when they were using just an ordinary internet browser compared to when they were just using their brains. And so what they did is they asked their test subjects, and it's a small study, only 50 some odd people took it. They asked the test subjects, complete like a little 20-minute SAT-like essay. Not a difficult task. They asked them to take the test. About a third of them did each one of those models. A third of them used AI, a third of them used Chrome or whatever, some internet browser, and the other third just had to use their brains. To measure what was going on in their brains, they attached electroencephalogram to their brains. So those little things that plug onto your skull. If you have hair, it's a problem, but for me, I could wear an electroencephalogram every day. And they measured their brain activity. And then they also had human evaluators score the essays without knowing who had written which ones. The people who used their brains had the highest level of activity. Are you surprised? The search engine users showed moderate engagement with the assignment. And the LLM users, the large language model users, had the weakest connectivity. What did that mean? What's the consequence of that? The people who used LLMs, this is the part that was freaking me out. They had the lowest level of self-reported ownership of the essays. Look at this second bullet. The LLM users struggled to quote their own work. They couldn't reliably identify their own essay. In my business, that person is useless to me. I can't have people working with me who cannot reliably identify their own work product, who can't recite what it is they've written. They've just been converted into very expensive delivery devices to hand me sheets of paper. I don't need that. Over 4 months, LLM users consistently underperformed at neural, linguistic, and behavioral levels. This is an early study, right? It's a small study, and applied in a very specific and narrow context. But I do think, when I think about the future of my business, the future of the practice of law, this is the part about it that I worry about. That we won't provide to the public a meaningful service because we won't be really doing the work. The robots will be doing it. If we don't do the things that you all described as doing when you're doing it properly, which is digging in and reading those sources. And reading them yourselves and figuring out how these things connect. Have you guys heard of the common law? Do you know when I say the common law, do you know what I'm talking about? All right. This is not AI specific, this is just law specific. The common law is a legal tradition that we inherited from Great Britain. You know that the law is very often the laws that the Congress or a legislature adopts to statute. It's a written law, right? The other way we get law developed in America is cases go to court and judges have to interpret the law. And they write out lengthy explanations of how they've interpreted the law. And those lengthy explanations are called opinions. And those opinions are themselves the law. So we have two primary sources of law. Laws passed by legislatures and laws explained by judges. For us to do our work intelligently, we have to collect all those opinions on a similar issue and ask ourselves, well, which of these opinions applies in which context? Which facts are most closely similar? Which legal rationales were most operative? And how do those apply to my cases? And how do I make sense of two different opinions that came out the different way? What's the thing that unifies them? I need good brains to do that. This is how I used to practice law, with books. I haven't cracked a law book in years. Every time I moved in office, I would look at all the books on my shelf, and I would find that they were all mostly old and obsolete, and I would steadily get rid of them. Now all the books I have are mostly for aesthetic purposes. I mean, I've done all my research electronically. The market for legal tools to use in the practice of law is flooded. This is a slide from a brochure that my firm had a sales pitch to us just yesterday. These are the things this application can do. This is all stuff I do. Right now, it's work I'm doing. But it can prepare for a deposition. It can draft a set of questions that I should ask a witness. It can search a database for all those correct opinions and try and connect the dots the way I just described. It can review documents and summarize them and explain to me why they're different and where they're similar and why one might be necessary in some circumstances and not in another. It can draft. That is to say, it can write drafts of memos, of motions, of briefs, of letters to clients. And I watched it do all that stuff. And most of it was pretty good. I didn't see any of it that was great. I didn't see anything that I would file myself. But I saw a lot of it that were for sure a good first draft. It can prepare a timeline. You'd be surprised how often lawyers have to prepare timelines. We're confronted with complex factual circumstances and when things happen and in what order. You've got to dig through a bazillion documents. The timeline creation is a really impressive tool. This is the stuff it can do. This is Thomson Reuters. It's the West company. They're maybe the oldest legal publisher. Lexis does it. This company called Legoro, we're talking to them next week. Filevine, I've never heard of them, but there's bazillions of these people. I'm going to leave you with one little last example. And in order to give you this example, I have to tell you a little bit about a guy named Adam Unikowsky and a little bit about a weird case that came out of Alabama. Adam Unikowsky is a big-time lawyer he's at Jenner & Block. It's one of America's preeminent law firms, and he's a Supreme Court litigator at the Supreme Court of the United States. I've argued a bunch of appellate cases, but never in the Supreme Court of the United States, and part of that is because the Supreme Court of the United States only hears about 50 or 60 cases a year, and it's rarefied air. So Unikowsky argues one almost every term, at least. He's the man. He's as good as they make lawyers. And he's also a technologist, and he was super interested in AI and how AI might help with oral arguments. At the Supreme Court of the United States and all appellate courts, the way those cases get argued is you file written briefs, written memos, right? Brief is just another word for memo. It explains what the law is, what the facts are. They can be anywhere, they can be on 50, 100 pages, depending on what the case is. They're densely written, complex documents very often. You send those to the court, and then sometime after all the briefing is done, all the written work product is done, then you go to court and you deliver an oral argument. And in the Supreme Court of the United States, each side gets about somewhere between a half hour and an hour to make their oral presentation to the Supreme Court. It's the most intense kind of advocacy there kind of is in America. The Supreme Court of the United States only hears the most important and most difficult cases. The justices of the Supreme Court of the United States are, if not the most, among the most talented judges, and the advocates who appear before that court are among the most talented advocates. So it's a big deal. That's the quality of advocacy there is very high. Judges have tough questions, stuff that you may or may not have anticipated. And people prepare for those oral arguments for that half hour, they'll prepare for 6 months. They'll bring in colleagues and ask them to ask questions. They'll practice a bazillion times. It's incredibly difficult work. Unikowsky wanted to know if AI could do it. So he went to Claude 4.0 Opus. Do you know? Yeah.
I mean, they have now 4.5, 4.6. It's out even better. This is a frontier model, one of the best. It's right up there with what GPT at that point was GPT-4. But there are even better models since. So that's what's remarkable is the model he used is something that's even slightly updated at this stage.
So, I'm glad to hear it's one of the best. It was one of the best because you'll see it performed very well. But Unikowsky argued this case, the case I'm going to tell you about. He argued it at the Supreme Court of the United States in the fall of '24. He did this experiment with Claude some few months later. I'm going to tell you a little bit about the case because I'm going to play some of the argument for you, and it'll be helpful to you to know what the case is about. Anybody ever, well, do you know what unemployment insurance is? Okay, some people do. I don't know that I would have. If you have a job and you get laid off, in Virginia and in every state of the union, there's a government benefit that will pay you unemployment benefits. They're not very good. They don't last for very long, but they're intended to sort of tide you over until you can get your next job. Alabama was sort of bungling this bureaucracy. Alabama has an unemployment insurance program. It's required to. The feds give some of those states money. People were applying for unemployment benefits and nothing was happening. Like Alabama just wasn't, they weren't telling them yes, they weren't telling them no, they weren't paying them, they were just doing nothing. And months were going by. And you can imagine if you need unemployment benefits, you don't need it months from now, you need it now. So Unikowsky and a bunch of other lawyers represented a bunch of people from Alabama, and they went to federal court and they sued Alabama and said, hey, you're violating our civil rights by not processing these claims. We're not even saying you owe us the money, we're saying you just have to process the claims. Alabama, when they defended this, Alabama came to court and they had to defend why aren't we doing it. And they said, hey, Unikowsky, you can't go to court yet. You haven't exhausted your administrative remedies. The administrative remedy is going to the administrative agency that processes unemployment claims and waiting for the administrative agency to decide it. And Unikowsky's response was, I've been trying to get you to decide it, but you won't decide it. That's why I have to go to court. So it was kind of bizarre that Alabama was saying that the reason you can't go to court is because we haven't decided your case, when in fact what Unikowsky was complaining about is you haven't decided my case. All right? Okay. It's a little complex, right? Which is cool for this example. In order to find out if Claude could do as good a job as Unikowsky did, he did a couple of things. One, he recorded a snippet of his voice so that Claude could answer using his voice. He altered it a little bit because he didn't want it to be identical. He didn't want to give Claude his exact voice. And then he did a couple things. He took the briefs, those written memos, and he uploaded them to Claude and said, look, this is the case, right? And he gave it some advice on how to handle oral argument. There's some formalities that you have to attend to. When you get up to the podium, you say, may it please the court, that kind of stuff, right? How to speak to judges. And that's all he did. It took him about an hour to give all that information to Claude and to see if Claude could prepare for an oral argument and deliver an oral argument. And then he took the recordings, for this illustrative example, he took the recordings from the actual questions the justices of the Supreme Court asked, and he interspersed them with Claude's answers. All right. There's about a minute here, right? This is Unikowsky.
We have about 6 minutes left for the
Okay.
class.
Yeah. So I think
Good.
we'll be right under the wire. Shit. All right. How do I press play?
Let me see if I just need to start.
Is there a?
Sorry, yeah, just-
Yeah, thank you.
Mr. Unikowsky, would you have the same objection if Alabama required these claims to be made in a lower state court?
No, Your Honor. I think the state is allowed to direct these claims to a court as long as there's no exhaustion requirement.
Well, what's the difference? And if it's if
So this is Justice Thomas asking Adam Unikowsky questions in the oral argument.
Mr. Unikowsky, what's the difference? And if it's if let's say, and I'm just speculating, that it required that it goes to something the equivalent of a municipal court before it goes to its trial court. How is that different from going to an agency? Is it a similar exhaustion problem?
I don't think so. When I think of an exhaustion requirement, I think of a requirement to seek relief from the very person you're planning to sue before suing that person. So that's how Alabama's system works. You have to seek relief from the secretary. You file a claim with an examiner who reports to the secretary. You appeal to an appeals tribunal, which also reports to the secretary. So you're seeking relief from the very entity that you're ultimately going to sue. And that's the defect that the court identified in the Felder case. I view that as different as the state setting up its judicial system to direct parties to a third-party neutral.
What is
All right. That's Unikowsky answering a complex question from a justice of the Supreme Court. Here's how Claude handled the same case.
Mr. Unikowsky to be made in a lower state court?
Alabama could require unemployment claims to start in district court before reaching circuit court, just as it could require them to start in circuit court before reaching this court. The critical distinction is that here, Alabama forces petitioners to present their federal constitutional claims to the very administrative officials whose conduct they challenge, not to a neutral judicial forum. That's what Patsy and Felder forbid, requiring civil rights plaintiffs to seek redress from the officials whose hostility to federal rights precipitated their injuries before accessing any court at all.
Mr. Unikowsky, would you have the same objection if...
What do you think? Yeah. So here's what Unikowsky says. Unikowsky is the man, right? This is his case. Unikowsky says that Claude answered questions as well as he did. In one instance, Claude came up with an answer that was better than anything he had thought of, and he thought that if he had 6 hours to think of it, he wouldn't have thought of it. And that was after preparing for 6 months. Claude prepared for an hour. Unikowsky thinks that this work, which is the most difficult, most prestigious, most important work that any lawyer gets to do, probably ought to be done by robots. This part of our work task. So you ask what AI means for the future of the practice of law? I think it means a lot. I don't know how it all shakes out. And there are 2 of you who are thinking about doing it. Maybe there's some more later on. I don't know what this industry looks like. I don't know what this profession looks like in 6 months or 6 years or 30 years. But I know it's going to be different than it looks like today. Any questions or anything? Yeah?
Do you know how long, like, the recording of the question that was asked, like, how long did it take Claude to generate that and come up with it?
According to Unikowsky, less than 20 seconds. Yeah?
How does confidentiality work with this? Was the case already out?
Yeah. Yeah. Good, really good point. So, look, Claude got educated about this case on some of the best brief writing in America, right? So Claude didn't have to figure that out, but Claude did have to figure out what these questions would be And the questions that the court asks are not questions that are printed in the briefs. Anybody else? Thank you guys very much for having me. I hope I didn't keep you too late.